All right, hello again. This is Ben Hitchcock Cross talking to you today. I've got a two-part recording of a teacher termination hearing from Marathon City, Wisconsin. This is up by or down by, depending on how you look at it, Wausau, Wisconsin. So yeah, we're like up here. That's about where we're at. Does your state fit within your hand? You tell me. So, we've got here, this is a Loudermill hearing, for lack of a better word, and the entire statute encompassing this hearing is like this. No teacher can be terminated without a majority vote of the full board. That's the law. That's it. There's nothing else. There's nothing more and nothing less. That is it. So, a teacher's contract is a contract unless it's terminated by right of the board. It's kind of weird that the contract, if the employer resigned, if the employee resigns, they have to pay the district money, but if the district terminates, then they owe you nothing else. I'm gonna have to think about that. I'm gonna have to think about that for a little bit. But there's two things that are going on here, and we'll get into the second one later, which is the open meetings violation. We'll talk about that in some detail, but in part two. Right now, we're just going to talk about what are the allegations and what's at stake here. Okay. Now, this is a pupil matter. There's no doubt about it. So we're going to have to there's a lot of limitations on who we can talk to, why we can talk to them, and about what kind of discussion they're going to have. And here I think we limited consciously some of the witnesses that we may have heard from because the testimony of the teacher was so strong. And I think there was a sort of a decision after that not to call anybody else because either they were going to vote in your favor or not. Now, let's talk about again the accusation. And they're serious here because um, what is going on is something that affects all teachers across the country. And this kind of situation here, where really a pupil's mom, uh, accuses a teacher of corporal punishment without really any kind of evidence, then there's a problem. Um, and we'll get into what I mean by evidence. So, basically, this is a new teacher where the new beginning of the year. When I say new teacher, she's not fresh off the boat. In fact, she's been a Navy veteran for many years. She has a master's degree, which is significantly higher than many teachers in Wisconsin, and she had taught elsewhere. So she's just new to this district. It's a new year. She, they had done their curriculum right now is focused on uh, the military. I don't know why that is, but that's what they're doing. The superintendent didn't seem to know why that was either, which was so neither did the principal, which was a little shocking, but that's how these things go. Um, I have some things I could say about the principal that I'll leave off. Let's moving it along. There is a child in this room. I think we call him student A, who, from what I can tell, is kind of immature and fairly naughty. And the things that he's described to be doing are really not anything that anybody in like an eighth grade would be doing that I have any experience with whatsoever. And I well understand that both the standards for discipline and the behaviors of the children and what the parents expect have completely changed. And that I think plays into this in a large part. But nevertheless, the behaviors that we're talking about here are just kind of shocking for me. So what's going on here is this pupil is bored or not stimulated enough, or I don't know, fidgety, whatever they may call it. He puts a pencil, he connects it with a bunch of staplers to the thick erasers and calls it a fishing pole, but is alleged to be whapping kids with it. Now, most schools that I know, that would be automatic. That's a weapon, automatic in school suspension. Is that insane? Totally insane. Totally insane. But that's how they would handle it. Zero tolerance, weapon, the end. Okay? So that's not what happens here. The kid is told to come. He's redirected with this activity, which is apparently doing some wall sits, which is part of these physical activities that the teacher and her husband had demonstrated as part of like Navy Day at the school, something along those lines. Um, she asks him if he would like to demonstrate, this is her words, the wall sit, and he does that. There is another child about 10 minutes late. He does that when we say he does a wall sit. He half-heartedly does a wall sit. Some of the other kids tell him to go to do it better. Not clear what he does it or for how long or whatever, but he's mostly sitting on a radiator reading a Where's Waldo book. Again, eighth grader reading a Where's Waldo book. That's a little bit strange to me, but okay. This channel is not about judging people, it's about pointing out issues. So, why the kids, everything's fine, all the kids describe it as a fun situation. She describes it as a redirection, a request, and not certainly not being made to do any kind of activity. Now, the pupil goes home to mom, tells mom what's happened, and mom immediately calls the police. Now, this is one of those districts where the police, they're both city, and there's one police department, there's one school district, and they're basically see themselves as co-equal branches of the municipal government. And so the police do what the district wants and vice versa. Like at this meeting when they wanted to quell dissent, they had a police officer, an armed police officer, intimidating people. They had the police department has issued referred charges of a violation of a Wisconsin school code, which I assume can only to the DA, which I assume only can come from the corporal Wisconsin corporal punishment law is in the school code. There's no crime, there's battery or assault or something like that, but there's no crime of corporal punishment in Wisconsin, as far as I know. Now, totally maybe wrong. Don't know. But the law that they cited as criminal is the school statute, and I don't get what they're doing. But again, that's evidence, in my opinion, that the school district and the police department are just co-equal branches of the same government. They work with each other. We get that allegation in Milwaukee all the time. There's that allegation with Holiday and the Milwaukee Police Department. There's recordings of them saying that they're doing favors for Holiday. Um, there's they put it in their notes, for goodness sake. So this is not something. This is not a new accusation in Wisconsin that the police department is working with the school district, not on behalf of the law, justice, or the individual citizens. That's what it is. So, if I wanted to have, I've said that I was afraid that people were gonna, at a public meeting, were gonna speak out and that I wanted the police to come there and intimidate people. That would they come? They wouldn't. So, and did they come at the request of the superintendent or the school board or I don't know. But well, that's not really what the issue is here. The issue is that then the superintendent took the students contradicted themselves. They made new their parents came to them and said they changed their stories. They did change their stories. They were interviewed multiple times. Things a stapler turned into this weapon, turned into I mean, there's that. Whereas the teacher says this is what happened. And the bottom line here is that this is what they did. You have 7 students. Nobody can cross-examine them except the superintendent, who's the one who presses the charges. And the superintendent decides that there's commonalities. Like, let's say there's 7 kids. 3 of them said this the same. And for this other thing, maybe 4 of them said that she made him come up. So therefore that happened because there's 4 of them, and there's only 1 of her. And ultimately she's cooked because any teacher is cooked because of the allegations. There really is no way for them to respond because the mathematical calculus of the district is let's just there's many holes in the administration story, but let's just keep this in mind. The only testimony at this hearing is that the superintendent has no clue how long one can do a wall sit, and the Navy veteran says that in her prime she could do it for 2 minutes. The allegation is that she made a child do a wall sit for 10 or to 30 minutes. Oh, it's also that she admitted to doing that, which is, of course, nowhere in the document. Didn't happen. So that really is the danger, and that's, I think, why so many parents were out there, so many teachers were out there, because if this could happen to one person, it could happen to anybody. It's all it takes really is for one parent to make the accusation, um, and then the teacher can be removed based on something that everybody in the room knows is physically impossible. It's all based on a lie. So this was the chance. Let's also be clear that the school district did everything in its power to keep this from being a public hearing. They noticed it as private hearing. They kept saying if she wants it. They kept telling the public that it was going to be closed, even though it was open. They put it in the smaller library. They had the police officers standing there intimidating people. And it was very clear, at least to me, that the superintendent and the board were communicating back and forth, and that the attorney who was working with the board had been working with the superintendent, and that this was a total foregone conclusion decision. So we'll talk about that in part 2. Thanks for sticking with us. We'll keep you informed. Wisconsin needs to do better.
Sorry.
Good evening, everyone. I'm going to call the School District of Marathon City Board of Education special board meeting to order this evening at 5 p.m. Can you please stand for the Pledge of Allegiance? The pledge is I do. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Beth, here. Please note the administrative staff that is present this evening. Written notice this meeting has been posted and sent to the news media on Monday, September 22nd, 2025, with a revised agenda sent on Tuesday, September 23rd, 2025. I am looking for a motion to approve the agenda.
I'll make a motion to approve the agenda.
First by Leah, second. Second by Beth. All in favor?
Aye.
Opposed? Motion carried. We are here this evening, is a hearing regarding recommended termination of an employee's contract, and this is an open session. Please note, if employee demands hearing to be held in open session, the hearing shall be held in open session. However, closed session may be entered when necessary pursuant to Wisconsin Statute 118.125, 20 USC 1232G, and Wisconsin Statute 19.18, 1F. To that end, the Board of Education reserves the right to consider a motion for and subsequently declare a closed session pursuant to Wisconsin State Statute 1918, 1, B, and F, and pursuant to Wisconsin Statute 118.125 and 20 USC 12332G for purposes of maintaining confidentiality of clinical records and for purposes of considering dismissal, demotion, licensing, or disciplinary of any public employee or persons licensed by a board or commission, or the investigation of charges against such person, or considering the grant or denial of tenure for a university faculty member and the taking of formal action on any such matter, provided that the faculty member or other public employee or person licensed is given actual notice of any evidentiary hearing which may be held prior to final action being taken, and of any meeting at which final action may be taken. The notice shall contain a statement that the person has the right to demand that the evidentiary hearing or meeting be held in open session. This paragraph and paragraph F do not apply to such evidentiary hearing or meeting where the employee or person licensed requests that an open session be held, and for purposes of considering financial, medical, social, or personal histories or disciplinary data of specific persons, preliminary consideration of specific personnel problems, or the investigation of charges against specific persons, except where paragraph B applies, which, if discussed in public, would likely have a substantial adverse effect upon the reputation of any person referred to in such histories or data, or involved in such problems or investigations. Any business conducted in closed session or subsequent open session shall conform with the stated agenda.
All right. My name is Attorney Davis Rundy. I am here as legal counsel for the Board of Education. I'm just going to make some introductory statements about the purpose of tonight and the kind of the guardrails that are going to be placed on tonight's hearing. So the purpose of the hearing tonight is to address administration's recommendation for termination of an employee's contract. The purpose is to determine what happened and whether administration's recommendation is appropriate or not based on the conduct at issue. Additionally, this is not an opportunity for public comment. This is in essence a legal proceeding, and the board expects all observers to be simply that, observers. Given the substance of this hearing, it must be stated at the outset that under no circumstances will pupils' names, identifying information, or otherwise protected information be shared in open session. If a witness intends to either name a student, provide enough information so that a student may be readily identifiable, or disclose information related to a specific pupil's educational record, for example, grades or discipline, then the witness is hereby informed that they must take efforts to refrain from such disclosure. As stated in the notice of this hearing, the board reserves the right to move into closed session in order to protect that information. Objections to such will be noted in the minutes. However, it is the board's hope that by giving this notice, all witnesses and participants in this hearing will adhere to this strict procedure. Using masking monikers such as student A or student B is acceptable, so long as such is not paired with other information which allows a student to be readily identifiable. With that said, and my indication that this is a legal proceeding, we are not in a courtroom. The rules of evidence do not apply, and the board is ultimately the overseer of this hearing, as it is their jurisdiction. So the board will accept evidence in certain forms. This is an informal, formal proceeding, as I like to call them, meaning, again, we're not in court, but we are putting formal guardrails on the hearing itself. What I mean by that is hearsay is allowed. I'm fine with witnesses presenting narrative statements. I do not expect administration, attorney Hitchcock Cross, or their client to necessarily engage in a question and answer style presentation. That does not mean, however, that there are not guardrails on the hearing We are limited to discussing the purpose of the hearing, what happened, and what should be done about it. Therefore, the information presented by the witnesses must be relevant to that inquiry. Additionally, there exists the general rule that if a witness is going to provide information to the board, such information must be truthful. Given these two general rules, I'm going to inquire with the parties about who they intend to call as witnesses and what they will be testifying to, generally speaking, essentially demanding an offer of proof. And then with that knowledge of who those witnesses are, I will ask all the witnesses to raise their hand, and I will swear all witnesses in, essentially requiring you all to tell the truth. So, administration, which witnesses do you intend to introduce here tonight?
We will be calling no other witnesses other than myself and Principal Wenke.
Okay, and what is the general contents of the testimony you will be providing?
The general content will be to walk the board through the original complaint that was received, the investigation, which included student interviews, teacher interview, and the relevant policies that are brought forth in this case.
And the investigation that you completed, did you and Principal Wenke complete that yourselves?
Yes.
Okay.
Although I would add that there was a police officer present during one day
Understood.
of interviews.
Attorney Hitchcock Cross, do you have any objections to testimony being provided by Ms. Woyak and Mr. Wenke?
No, thank you.
Thank you. Attorney Hitchcock Cross, who do you intend to call as witnesses then?
So I believe my client and possibly also Miss Emily Schiller.
Okay. And what is Emily Schiller going to be?
She's aware
Testimony.
of some of the statements, I guess, after the event by some of the witnesses, and that which may shed light on the truth or veracity of their statements.
Okay. Are those the only two witnesses?
That's my understanding.
Okay.
I mean, obviously we're reserving rights depending on what's said here and whatever
I'm gonna-
else.
yeah, I'm
And
gonna
I
give you-
understand you may want an offer of proof, which I don't necessarily have a problem with that. But with everything else in mind, that's where we're at right now.
Okay. And I'll give you every opportunity, as I'm going to explain a little bit, to cross-examine them on what they are going to testify to.
I appreciate that. I'm just saying there may be some witness that may come up that we hadn't anticipated based on their testimony. But other than that, that's our plan so far.
Okay. At that time of you intending to call that witness, I'll have the same inquiry with you, okay, about the contents of
Yeah,
their
clear-eyed.
testimony.
Yep.
Thank you. Where is Ms. Schiller, just so I'm aware? Okay, thank you. Ms. Schiller, did you hear me clearly about the need to refrain from disclosing any student information?
I do.
Okay. And can you commit to me that you will abide by that?
Yes, sir.
Okay. I want, to the best of our abilities tonight, to respect Ms. McCarthy's rights to have this in open. And so by you agreeing to do that, that will assist this process. So I appreciate that. All right. Then the general procedure here tonight will be, I'm going to allow administration to present the information they'd like to present to the board. I will give Attorney Hitchcock Cross the opportunity for cross-examination. I will also give an opportunity for the board to ask any questions of administration. The same procedure is going to be given to Attorney Hitchcock Cross. I will give you the opportunity to present your case. I will give administration the opportunity to cross-examine, and I will give the board the opportunity to ask questions. Are there any questions about that procedure?
Not from us.
Okay. Following the two presentations, the board as agendized, we'll move on from, I believe it's agenda item 6 to agenda item 7, closed session for deliberations. At the time of entering into deliberations, all people present here right now will leave the library. My understanding is there's space set up in the auditorium for you all to go. And the board is going to enter into executive session to deliberate this matter. Following deliberations, the board will come out of closed, go back into open session, and announce its decision. All right? Any questions about that? Okay. Having gotten through the procedure of tonight, I'm going to touch on some basic kind of legal standards. So the appropriate standard for tonight is set out in the board's policy 3140 sub B, which is a full-time teacher's contract may be terminated only by a majority vote of the full membership of the board. I want to confirm that we do have a full membership of the board present tonight.
Yes, we do.
Thank you. The district administrator shall, if deemed appropriate, recommend a teacher's termination of the board. The district administrator is responsible for providing the teacher with appropriate notice regarding the hearing and for taking the necessary steps to present any such recommendation to the board. On that point, Ms. Woyak, could you please confirm that notice of tonight's hearing was provided to Mrs. McCarthy?
Yes, it was provided.
And is there written evidence of that you intend to produce tonight?
There is. This is probably the appropriate time. That written evidence is in this packet.
And Attorney Hitchcock Cross, did you get a copy of the packet that was?
No,
Okay.
I
Let
didn't.
me have my packet.
Thank you.
Okay.
That notice are the last 2 pages of that packet.
Okay, thank you. Any questions before I swear everybody in? No? Okay. So if you're going to, Attorney Hitchcock Cross, I don't intend to swear you in. I suspect everything you'll be presenting tonight will be by way of argument. So I'm going to swear in Ms. McCarthy, Ms. Schiller, Ms. Woyak, and Mr. Weinke. I'm just going to ask that you all raise your hands. Excuse me. At the same time, I'm going to read my question. No, you can keep your hands raised.
Okay.
And I'm going to read my question, and I'm going to poll you for yes or no. Okay? Do you swear to tell the whole truth, nothing but the truth, and only but the? Do you swear to tell the truth, the whole truth, and nothing but the truth? Mrs. McCarthy.
Yes.
Ms. Schiller. Ms. Woyak.
Yes.
Mr. Weinke. Yes. All right. Thank you. All right. With that said, then, I will turn it over to Ms. Woyak to begin her presentation.
Certainly, thank you. So this presentation will in essence walk you through what we learned after receiving a complaint on the evening of September 9th. So I will do so from the moment that complaint was received, through each interview that occurred, and through a summary of findings. So on the evening of September 9th, school administration was contacted by a Marathon City police officer who indicated a parent of a student reported that Mrs. Jessica McCarthy had used corporal punishment in the form of a 30-minute wall sit for her child and sundials for another student. The alleged incident occurred during 8th grade ELA class that same day of school, on September 9th. After receiving that, we commenced an investigation immediately the following morning. That began at approximately 8 o'clock. And it occurred at the Marathon Area Elementary School. So that occurred on September 10th. Administration contacted the complainant by phone and took the allegation directly. What we learned was the incident occurred on September 9th at 1 p.m. in ELA class. Another student had taken her child's stapler and took it back. Mrs. McCarthy assumed they were misbehaving and instructed her child to go up in front of the class and do a wall sit. Her child had to stay up there until the class was over. The complainant alleged that Mrs. McCarthy did not ask her child if they were hurting. The complainant alleged that Mrs. McCarthy did not tell her child how long to do the wall sit. The complainant indicated that her child said it hurt and that her child was distraught. She alleged Mrs. McCarthy showed no regard and never spoke to him. That was the complaint. We interviewed a number of students. I'll begin going through the outcomes and the points from each of those interviews. Those interviews involved questions, and they involved the students demonstrating what the action was, what the wall sit was, what the sundials were. So student number 1 indicated that it was the second half of class. They had started about 10 minutes later than the bell, and the bell had rung. So the bell typically rings at 12:45. So it started 10 minutes later. Student A was goofing around and took their pencil back from up here. About 10 minutes into class, Mrs. McCarthy called student A's name and gestured with her finger. Student A did a wall sit in front by the window for 15 minutes. Student B did sundials by the door for 10 minutes. He was laughing. This is the first time this has occurred. That was student 1. The interview with student 2 indicated that student B had to do 10 push-ups and 10 air squats while passing out papers. Student A was twirling a pencil contraption. Student A was called to the front and told to do a wall sit for about 15 minutes. And a classmate said 6, 7. Student B was called up and told to do an arm circle. Student B reported feeling embarrassed. Interview of student number 3. The class was writing stuff in their notebooks. Student A had to do a wall squat because he was messing around with a pencil and eraser. This is normal. Peers were critiquing student A. Mrs. McCarthy just looked at student A and said nothing. It lasted for about 15 minutes. Student B had to do arm circles, maybe because they had skipped a peer when passing out papers or they were being silly. The interview also mentioned hearing a warning, but nothing said by Mrs. McCarthy during the wall squat or arm circles. This is the first time this has occurred. The student thought maybe Mrs. McCarthy was doing this to students because she had been in the military. The interview with student number 4 indicated toward the beginning of the second half of class, something happened. Student B said something or was mouthing off. Mrs. McCarthy told him to do 10 push-ups and 10 air squats. Everybody thought it was funny, and student B complained that it wasn't fair. Then toward the middle of the class, student A was playing with a pencil, some staples, and an eraser. It was distracting. Student A also tried to get a stapler back from a peer. Mrs. McCarthy told him to stop it and to do a wall sit. Student A did the wall sit for quite a while, but took breaks by sitting on the wall vent that was right below. Other boys said that's not how you do wall sit to student A. Student A corrected, but then would take breaks and sit down. The class giggled. About 10 minutes later, student B was correcting student A, telling him to do the wall sit correctly. Mrs. McCarthy made him do arm circles. There was not a warning that exercises would be a punishment. The interviewee recalled Mrs. McCarthy telling the class that she had to do wall squats and arm circles in the military for 30 minutes. Interviewee recalled Mrs. McCarthy telling student A that he needed to be at a 90-degree angle and telling student B to keep their elbows straight and keep going. At the end of the class, student A went to Mrs. McCarthy and told her that a peer had been the one to actually take the stapler. Student number 5. Class was finishing ELA work and working on a program called Word Gen. It's like word study. The student indicated that there's a rule that we can't say 6, 7, or we have to write a second book for the project. Then at the beginning of class, a person at the table said 6, 7. Another peer reported it. Mrs. McCarthy said it was unnecessary and a disruption. She made student B do 10 push-ups and 10 air squats. Then, in the middle of class, Student A was being disruptive with a pencil and connected staples to the pencil. They had to do a wall sit for 15 to 20 minutes. Sometimes they leaned forward or straightened their legs or sat on the vent to take a break. The interviewee recalled the class asking student A 2 times if they were okay, and Mrs. McCarthy asking the student 1 time. The interviewee did not recall hearing Mrs. McCarthy give student A a warning. Then closer to the end of class, student B had to do arm circles for 8 to 10 minutes. At first their arms were out to the sides, but then Mrs. McCarthy corrected the student and had the student switch to putting their arms out in front. The interviewee recalled Mrs. McCarthy giving student B a warning or prompting the student. The class was laughing and shocked that it happened and how long it went on. They were wondering if this is what we will have to do. The interviewee indicated it was too long. Student number 6 was then interviewed. Student number 6 said a peer had stolen student A's stapler. Mrs. McCarthy said to student A to stand up and do a walk. It lasted from 1:05 to 1:30 p.m. Student A's legs got sore. The interviewee reported that student A was tired, unhappy, and kind of in pain. A couple of students told student A that's not how you do a wall sit. Mrs. McCarthy kept looking at student A, and she might have asked, "Are you sore?" about 8 minutes into the wall sit. There was no direction given for another 20 minutes. At the end of the class, Mrs. McCarthy asked student A what had happened. Student B did something and had to do arm things for 17 to 20 minutes. At this point, we concluded that the wall sit and the arm circles, or otherwise known as sundials, had occurred, and we needed to gain greater understanding from Mrs. McCarthy. We interviewed Mrs. McCarthy the next day, September 10th. During the interview, we realized she was reading from her phone, a series of notes. We asked Mrs. McCarthy if she'd be willing to share her notes with us. She did so. A copy of her email indicating her notes is included in your packet. I'll now go over a summary text from her notes as well as the interview with Mrs. McCarthy. First of all, we began the interview with a review of her guarantee rights. Mrs. McCarthy affirmed that she had received and reviewed the employee handbook and the MBA handbook. She affirmed that she was present when MBA staff reviewed the minor and major behavior infraction grid and discussed staff responses to infractions. Mrs. McCarthy indicated that she typically handles minor infractions in her classroom and she tends to take care of things herself. With majors, she could write them up, help her, have them in class, or call administration. Mrs. McCarthy reported that she's been covering a unit regarding the military, and there have been many student questions, so she's been sharing her experience with them. She explained to them that when people mess around in the military, they have to do exercises. Mrs. McCarthy affirmed that she had a student perform a wall sit. The student took a pencil, jabbed staples into it, and created a string of staples with attaching an eraser. He reported that he hit another student with it. She indicated it was a distraction and a safety concern. Mrs. McCarthy reported asking him multiple times to stop. Mrs. McCarthy saw him lunge across at another student, and that is an immediate no for her. She told him to come up front and do a wall sit. It lasted 10 minutes. Student A ended up sitting, grabbed a book from a nearby basket, and fidgeted. Student A did not complain, and she kept an eye on him. They gave him feedback and Student B was interrupting, distracting, flirting, and causing a disruption with a group of boys. He was shoving and kicking, trying to get a girl's attention. Mrs. McCarthy reported redirecting him multiple times. She thought outside the box and used another military boot camp workout, sundials. This is what she reported. Mrs. McCarthy had student B do sundials at the back of the room for 5 minutes to stop the distracting behavior and give him a movement break. She stated that she tied it to the lesson when goofing off in the military. You had to do this. The class was joking and smiling. Mrs. McCarthy asked if student B was quarterback for the whole game, and he said yes. At one point, student B shook his arms down, and she told him to put them out in front of him and continue. Sundials lasted for about 5 minutes. The whole class was laughing, smiling, and joking around, according to Mrs. McCarthy. In the interview, when I told Mrs. McCarthy the definition of corporal punishment, Mrs. McCarthy didn't seem to realize or think that the wall sit and sundials were included in that definition. At that point, as administration, we realized that we needed to corroborate Mrs. McCarthy's account of everything that occurred, and we conducted one new student interview, and we went back and re-interviewed students. I'll go through those findings. So a second interview with student business. Student A created a pencil with staples connected to it in science class early. Student A took it to ELA and handed out the entire class. Student A did not twirl or fling the item, according to student number 6. Mrs. McCarthy did not give a prompt or redirect to student A to put it away. Student A was directed to do a wall sit. Mrs. McCarthy did not say anything about the military at that time. The wall sit lasted about 30 minutes. Mrs. McCarthy looked at student A during the wall sit but didn't say anything. Others in the class corrected student A's wall sit. Mrs. McCarthy did not. While student A was doing a wall sit, Mrs. McCarthy took the item away from a peer that had picked it up and started playing with it. The peer was sitting at the same table as student A. At the end of class, Mrs. McCarthy asked student A what had happened. We then interviewed a new student, student number 7. In class, they were studying veterans and stuff. Mrs. McCarthy had talked about her military experience the week before during the kickoff, said she had to do 30-minute exercises for endurance. The interviewee recalled student B doing arm circles, thought it might have been because of saying 6-7. The interviewee could see why this would be distracting. Mrs. McCarthy had redirected student B 1 to 2 times. Mrs. McCarthy told student B to stand up and do arm circles. Lasted about 10 minutes. Student B said their arms were getting tired. The class laughed. The interviewee indicated student A fidgets a lot. Student A had made a thing like a mini fishing pole with staples connected to the pencil, and he was trying to pick up an eraser with it. Student A had been playing with it for about 20 minutes while listening. He did not swing it or cast it, according to the interviewee. He did not recall hitting, that anybody got hit with it. Mrs. McCarthy didn't tell student A to stop and put it away. A student had taken student A's stapler. Student A tried to get it off. McCarthy told student A it lasted until the end of class, about 15 minutes. Student A appeared fine, comfortable, not mad. Student A sat at the wall bench. Mrs. McCarthy told him to do a wall sit and not sit on the bench. Didn't ask him if he was okay. The interviewee did not recall Mrs. McCarthy making a connection between the wall sit and our last interview was a re-interview of student number 1. Student number 1 recalled student A twirling his pencil thing, but it didn't hit anyone, and he didn't think it was a distraction. The wall sit lasted 25 minutes. Student A adjusted his body during the wall sit. When told to do the wall sit, Mrs. McCarthy said nothing other than to the wall, and he said the words wall sit. Student B and peers were grouping off, probably talking. Mrs. McCarthy said, "Come over here," and had him do arm circles for 20 minutes. Interviewee did not recall hearing a redirection or prompt. The interviewee had no recollection of Mrs. McCarthy's connection between the military, wall sit, or sundial consequences. The interviewee recalled the military only being discussed on the previous Thursday, September 4th, during kickoff stations. That concludes the review of our interviews. So, based on the investigation, what we did, at that point did was look at all of the consistent reports across all interviews to determine and derive what would be our findings. You have in your evidence packets that memorandum. I believe it was the first 2 pages. And I'll begin going through what we determined to be those findings. It begins about 3/4 the way down that page. So we determined that during 7-hour ELA RTI, an 8th grade student A, was directed to do a wall sit at the front of the classroom by Mrs. McCarthy as a disciplinary measure in response to student A's classroom behavior. Student A was directed to hold the wall sit, and it lasted until the end of the class period. The reason student A was disciplined involved student A fidgeting with a pencil with staples connected to it and using it similar to a mini fishing pole to pick up an eraser on his desk. There were mixed reports by students on whether this was a distraction to other students. According to all student interviewees, there was not a redirection or prompt by Mrs. McCarthy to put it away. Student A's peer took student A's stapler and did not readily return it when requested. Student A leaned over and took it back. He was then called up to the front of the classroom by Mrs. McCarthy when she phased his name and gestured with her index finger, communicating to come up front. Mrs. McCarthy directed student A to do a wall sit. The duration of the wall sit is undetermined, with Mrs. McCarthy indicating it was 10 minutes and students reporting 15 to 30 minutes. There were reports that student A took breaks by sitting on the wall vent or leaning forward. We learned that student A has not had a history of disciplinary issues. It was reported that student A did not appear distressed. However, when asked if he was distressed or felt pain, student A responded, well, kinda, yeah. It was also reported to administration that the class laughed until the student A in his performance of the wall sit. While student A was enduring the wall sit, another issue student B, was directed by Mrs. McCarthy to do sundials and arm circles at the back of the classroom until the end of the period. Similar to student A, Mrs. McCarthy's direction was in response to student B's classroom behavior. It's not clear what the exact behavior was that resulted in student B being disciplined, but the reports included not passing a paper to a peer, using the word 6-7, flirting, or engaging in other distracting behavior. The interviewees indicated that student B appeared to fatigue and then had to do arm circles in front of his body as opposed to out at the sides, as directed by Mrs. McCarthy. So the duration of the physical exercise that was used as student discipline were ranges that varied by interviewee. The wall sit to student A estimated between 10 minutes to 30 minutes. The sundials to student B estimated to be 8 to 10 minutes. Within the 8th grade curriculum, the expeditionary theme is veterans and service. The previous week, there had been sessions with veterans and explanations of the branches of the military. Mrs. McCarthy and her husband had led one of the sessions as veterans. Mrs. McCarthy self-reported that she used military strategies as student discipline, which she was subjected to during her military service and boot camp. Mrs. McCarthy reported that she couldn't take care of things by herself or within the confines of the classroom. She did affirm that she had read the employee handbook and the MBA handbook. There exists an acknowledgement of receipt of that handbook. That's all within the packet. Signed by Mrs. McCarthy. She affirmed that she had participated in a meeting during which MBA teachers had collaborated on teaching responses to both market and major behavior infractions. No assistance had been, from administration, had been requested by Mrs. McCarthy to assist with student A's or student B's behavior. No file of a minor or major behavioral infraction specific to either student A or student B was made by Mrs. McCarthy on September 9th. Mrs. McCarthy is a first-year teacher with the district, previously serving in a substitute role. Those were our findings. There are a few relevant statutory and policy authorities to this incident and this matter. I've included those within the evidence packet as well. First of all, there's Wisconsin Statute 118.31, corporal punishment. It states it means that intentional infliction of physical pain which is used as a means of discipline. It does not include actions consistent with the student's IEP or reasonable physical activities associated with athletic training, that no official, employee, or agent of the school board may subject a pupil enrolled in the district to corporal punishment. We have some policies here in the school district. Policy 5630, which is corporal punishment. No official employee or agent of the board may subject a student enrolled in the school district to corporal punishment. If they intentionally inflict or cause to be inflicted physical pain by hitting, paddling, clanking, slapping, forcing, prolonged maintenance of physically painful positions, or make use of any other kind of physical force as a means of disciplining a student, she or he may be subjected to discipline up to and including discharge by this board and possibly criminal assault charges as well. There's policy 3213, student supervision and welfare. As employees, we shall maintain a standard of care for the supervision, control, and protection of students. There's policy 3210, that's also relevant, staff ethics. It requires the services of employees to hold integrity, high values, and human understanding. It expects all professional staff members to maintain high standards and exercise due care to protect the mental and physical safety of students, colleagues, and civilians. All of those are in your packets. So, in conclusion, the situation and Mrs. McCarthy's actions on September 9th, the sixth day of school, fall below the expectations of the district and its staff. By all accounts, Mrs. McCarthy's actions, which she by and large admits to, violate Wisconsin's prohibition of corporal punishment. 2 students were required to engage in prolonged physical position as a response to misbehavior that was intended to result in physical discomfort, and in one case, the student reported pain. This is an unapproved and illegal form of discipline. And with all due respect to Mrs. McCarthy's military service, our schools are not military boot camps. The action does violate state law and school district policy. Let me be clear, this is not about who Mrs. McCarthy is as a person. It's simply about her actions on September 9th that directly impacted the district's trust in her to carry out her responsibilities in accordance with the policies and procedures of the school district. Ultimately, we are charged with safeguarding the welfare of our students and keeping them safe.
Thank you.
Principal Winky, is there anything that you would like to add?
Yeah, if I could just have a moment to summarize in my perspective, that the factual findings of the first set of interviews and kind of where we went from there. We interviewed 7 students, some of them several times, all of them independently of each other, and these were lengthy interviews, and several things were very, very consistent. That there were no warnings or redirections or asks to stop the behavior that caused the consequence. That students were allowed to correct and critique and laugh at the students that were doing this. That the student who was doing the sundials experienced fatigue to the point where they could not keep their arms out to their side and were directed to switch to being in front of them to continue. Something that was somewhat inconsistent was the times that the students gave us. We received anything from 15 minutes to 30 minutes, but the one thing that was consistent with the times was the ending point, that these went until the bell rang. There was no intention to allow this to end until the bell rang. Our perspective changed a little bit when we interviewed Mrs. McCarthy. She presented to us the context of the military, that we are studying the military right now, that is factual, that is the 7th and 8th grade focus, that she was in the military and recently gave a presentation, that is also factual. She provided us the context that these were things that were done as almost demonstration type things, because students had been continually asking about her time in the military, and that it was almost part of the class. Unfortunately, in the first set of interviews, that connection was never made by any students. That was never brought up. When we took that context as part of our reasoning for going back to interview more students and re-interviewing other students, And we specifically asked about that context, and all of them denied making any connection to that, or that it was ever brought up. So that's another thing that we found.
Anything further in terms of presentation at this time? Attorney Hitchcock Cross?
Great. And so I'm going to have a few questions for you. Can you hear me okay? Okay. So what is a wall sit as you understand it?
It's placing your back against the wall and holding your legs at a 90-degree angle.
Okay. And you understand that's a pretty physical exercise, right?
Yes.
Okay. And you understand and agree with me that that's something it's impossible, really, for an eighth grader to do a wall sit for 30 minutes, right?
I have not witnessed that, so I can't answer that.
Okay, but you'll agree with me that that would be, before you recommend the termination of a teacher, that would be something that would be important for you to figure out, right?
I'm not sure quite how to understand if I have to answer that. That's a subjective response.
I
Okay.
think that's a sufficient response.
Okay.
Okay. So do you feel that it's physically possible for an eighth grader to do a wall sit for 15 minutes?
I have no direct experience with that. I don't know.
Okay, did you take any steps to find out?
I did not.
Okay. Now, let's talk about the investigation for a little bit. You started the investigation, right?
Yes.
Okay. And there's two investigations that were going on simultaneously. That's also true?
Yes.
Okay, and that's law enforcement and the school district one, right?
Yes.
Okay. And the school district, in fact, allowed law enforcement to be present while these interviews were conducted, right?
On September 9th, yes.
Okay, so there was additional interviews that were not conducted by law enforcement, is that fair?
Law enforcement was not present on September 10th during our interviews.
So that's a yes, is that fair?
Law enforcement was not present on September 10th.
And you interviewed children, other pupils on that date?
Correct.
Okay.
As well as Mrs. McCarthy.
I got it. Okay. And how many students changed their story at any time?
Can you rephrase that question, please?
Well, sure. I mean, you had some students gave you one story originally, right?
Mm-hmm.
And then at least one parent came to you and told you that pupil had changed their story, right?
I don't recall receiving that information.
Oh, okay. And so you didn't re-interview another student because the parent contacted you and said that student had changed their story. Is that true as well?
That's true. We re-interviewed after interviewing Mrs. McCarthy.
I got it. Okay. Were you in contact with law enforcement between the 9th and the subsequent interviews?
I do not recall.
Okay. So, it's fair to say that, were you present during any of these interviews?
I was present during all of the interviews.
Okay. And do you think the students knew who you were, what your position was?
I explained to each student at the onset who I was and my purpose.
I additionally put it into middle school friendly terms, identifying Mrs. Woyak as my boss.
Okay. So they knew you had a pretty powerful role in the district, right?
I would assume so.
Okay. And who asked the questions?
I asked the majority of those questions.
Okay. And you're also the person who recommended the termination, right?
Yes.
Okay. And while you were asking those questions, you were also making judgments on what was going on, true?
I was interested in finding the facts.
Okay. Is that a yes or something else?
Something else.
Okay. So then, you'll agree with me that when you were interviewing students, the students gave you several different answers as to how long these exercises took place, right?
The students indicated, according to the facts, a range of 15 to 30 minutes. Mrs. McCarthy indicated 10 minutes.
Okay. And let's just, while we're on that, can you tell me where exactly Ms. McCarthy indicated 10 minutes?
When we interviewed her
Okay, but that's, and you said that she provided, she was reading verbatim, right?
during a portion of the interview, she was reading verbatim.
Okay. And then she also said she gave you what she was reading from verbatim, true?
Yes.
Okay, and then you provided that to the school board, right?
Yes.
Okay, and so I've got a copy of that in front of me here. Do you have one of those too?
Yes.
Okay, and it's just, if you can help us out and show somewhere in there where it says something like 10 minutes, that probably will be helpful.
She didn't indicate it in here. She
Okay.
told it to us when I was questioning her.
Ah, okay. Okay. And did you ever check whether or not a 8th grader doing a wall sit for 10 minutes was physically possible?
No.
Okay. Okay. So, and at some point, you'll agree with me that the stories of the children that you interviewed and Miss McCarthy agree, right?
Would you please repeat that question?
Sure. The children and the teacher agree on some points, right?
Yes.
Okay. And they disagree on other points, fair?
Yes.
And it's also true that at every point that they disagreed, you sided with the students, right?
I provided the consistency and the facts. My findings of facts were basically what was said across interviews.
Well, sure. I appreciate that. So did Miss McCarthy change her story at any time?
I only interviewed Mrs. McCarthy once
Okay. So you'll agree with me that she was pretty consistent, right?
within her one interview.
Right, okay. But then you got the children were not consistent, right? Just for example, you'll agree with me that student 1 first said that what was taken was a pencil, stapler, and then it changed into a pencil with some staples on it, right?
Repeat your question for me.
Sure, you'll agree with me that student A first told the police that someone stole a stapler from his desk and they were horsing around, and then it turned into a pencil with some staples on it, right? During the second interview with you. You'll agree with me, right?
So you're asking what student A reported during each of student A's interviews, is that correct?
That's right.
Okay, just needed clarification.
Well, and I'm asking you if that changed.
Student A's
Story, right, he
story
changed.
did not change.
Okay. So student A always said that he was playing around with a makeshift fishing rod, right?
So in the first interview,
Mm-hmm.
student A indicated a peer had stolen student A's stapler.
Okay. And that was the reason he was in trouble, so-called, right?
Right.
Okay. And then did that ever change? The reason he was in trouble, did that ever change at any time?
Then in the second interview,
Mm-hmm.
student A also indicated that he had been playing with a pencil with staples connected.
Got it.
That was in response to direct questions from me after interviewing Mrs. McCarthy.
Okay, so you'll
She
agree
reported that.
the first time he had one statement, and the second time he added to his statement, right?
Yes, in response to direct questions from
Okay.
me.
And that's the consistency we're talking about, right?
Are you waiting for a response from me?
Right, yeah, that's how it goes, I think.
Can you repeat the question?
Sure, that's the kind of consistency that we're talking about, right?
How do I do I have to respond to that?
I think his question is, Hitchcock Cross, I'll give you an opportunity to rephrase it if you'd like. based on the reports you received from student A, did you find those reports to be consistent with one another or not?
Yes.
And I believe Attorney Hitchcock Cross is saying because he said one thing in first interview and then added to
Added
that second hearing, in that second interview, do you deem that to be inconsistent?
It's not inconsistent, no.
If I may, the student added in more detail in the second interview after direct questioning from us. There was no change in what was previously reported, it was simply more detail shared.
Okay. And based on all your questions, you were never able to figure out what exactly student B ever did that was supposedly wrong, right?
Correct.
Okay. And you'll agree with me that for someone to be punished for something, they have to have done something wrong in the first place, right?
I would assume so, yes.
Okay. Well, you can't think of an example where somebody is blameless and then being punished, right?
That is not in accordance with our policies and procedures.
Okay. I got it. So, it's also not in accordance with the evidence that you got, right?
So the evidence showed, the facts showed, and it was consistent that student B had been engaging in some level of distracting behavior, using the phrase 6-7, blurting out.
Sure. But he could have been jaywalking, but the fact is that you had no evidence to connect whatever alleged behavior that he engaged in and whatever supposed consequences that you're alleging here to the board. Also true? Well, can I have just an answer to my question first? And then if you need some assistance, maybe that would be an appropriate time after you answer my question.
Okay, would you please repeat your question?
Well, so you'll agree with me that it doesn't matter whether or not the pupil was accused of jaywalking. The important part is a connection that you are aware of because you're making the allegations to this board between some behavior on the pupil's part and this exercise, right?
I'm failing to see where you're going with this.
Okay. But you didn't fail to see. I mean, you signed a letter to this board saying that my client should be terminated because she did corporal punishment on student B, right? Where you agreed with me there, right?
Yes.
And you agree in front of all these people that you don't have any evidence that there's any connection between any action that student B ever possibly took. And you'll also agree with me that there's many variations of things that student B may have done, but you have no evidence, even though you recommended charges, that there's any connection between student B's activity and the alleged exercises, right?
All findings and facts, as well as Mrs. McCarthy's report, indicated the antecedent to the sundials was student B blurting out, distracting, using the term 6-7, and other disruptive behavior.
Okay, so that means it happened before, right?
Before, and that there was a connection.
So now there's a connection. So what's the evidence that there's a connection? Because
I think
Mrs.
Attorney
McCarthy.
Hitchcock Cross, that's a little argumentative, and that's ultimately for the board to decide what that connection is.
well, what did you allege to this board that the connection is?
Mrs. McCarthy stated in her written response to us, student B was also making poor decisions and a distraction and was interrupting and blurting and causing disruptions with a group of boys in the front. He was shoving and kicking. He was messing with a bandage and was trying to get a peer's attention. So thinking outside the box again, writes Mrs. McCarthy, I had him move to the back of the class and do sundials, where you move your hands in circles. Mrs. McCarthy, according to her own admission, connects the behavior with the sundial.
Okay, but she says more than that.
And you intentionally stopped there, didn't you?
Oh, I can-
She says, by doing this, my thought was to get him up and moving around, and were not punishments, and were mainly to get him away from his friends and moving and standing up so as not to disturb others so he could walk around. She said that to you too, right?
Yep, it stayed here. Yes,
Okay. And you have education as an educator, right?
yes.
Okay. And you're aware that redirecting a pupil is a recognized educational technique, right?
Yes.
She goes on to say, because it was successful, right? I was able to continue on with my lesson. You'll agree that that's the whole purpose of teaching, right? Is to have a lesson.
The purpose of teaching is for students to learn.
Yeah.
Deliver their lesson to students to learn.
Okay, and that's in fact what this board pays this teacher to do, is to teach her lessons, right?
Teach lessons and carry out the policies of the school district.
Okay, and you'll agree with me that disruptive students prevent her from doing that, right?
Disruptive students, yep, can be disruptive.
Okay, and you'll agree with me that redirection is an appropriate educational technique, right?
Yes.
Okay. Are you aware of whether or not there's a final police report in this matter?
Yes.
Okay, and when did you become aware of that?
Today.
Okay, and have you reviewed it?
Not in detail, no.
Okay, but you reviewed some of it, right?
I looked at it to see if it contained names.
Got it. So you're aware then that the police put in their report that on Monday, September 22nd, 2025, at approximately 1:53 p.m., this is the police officer, Mr. John Lee, said, I made contact with a parent. A parent and I set up an interview time at 5:30 on the same evening. The parent said a pupil changed his story. The parent said the story changed more towards protecting his friends. The parent, and I'll leave that at that. You're aware of that, right?
No.
Okay, so when you skimmed the report looking for names, that passed you by?
Yes.
Okay. And would that, if you had read that, do you think that that's something that would have been changed your feelings about pressing the charges here today?
I received the report this afternoon, sir.
Okay. And so had you read that information and read that report in detail and been familiar with the part that I just read from the report, would that have changed your recommendation to this board?
The recommendation was based on whether corporal punishment occurred.
Okay. So again, and you interviewed pupils, you believe the pupils, and hear information that a parent is saying that one of the pupils changed their story, that wouldn't affect your recommendation at all, right?
Again, we looked for consistencies in our investigation. Our investigation was separate from the police investigation.
Okay, but you'll agree with me that a parent coming to the police and saying that their child had changed their story is the very definition of an inconsistency, won't you?
It can be construed as inconsistency. I was not made aware of it. I received that report this afternoon.
Okay, and you're aware that we asked to have this meeting postponed so that all the facts could be found, right?
I learned of that this afternoon.
Okay, and that also probably would have been helpful information for the board to know in making their decision here today, right?
My purpose is to carry out the policies of the school board and the school district. I had concluded findings based on consistencies in our interviews and I was ready to present this to the board this evening.
Okay, so you'll agree with me that no matter if you have information that changes the facts that you present to the board, according to what you just said, it's not part of your job to present that conflicting information to the board, right?
Ready to answer that?
I'll withdraw the question. That's why when you were given the opportunity to read from this document, you stopped reading before Miss McCarthy said that she wasn't punishing the child, right? You chose to do that on purpose and not read out that information to this board, true?
Sir, I was trying to answer your question, and I had thought I had finished answering your question by reading that portion.
I understand. I understand. Okay, and you're brand new as a superintendent here in Marathon City, right?
Yes.
Okay. And it's also true that not only you haven't waited for this board to make a decision, right?
Can you please explain or rephrase that question?
Sure, you'll agree with me that this board sitting right here today is your boss, right?
Yes.
And under the statutes, they're the ones that have the decision, that are supposed to make the decision on whether or not corporal punishment is happening, whether or not this teacher should stay in this district, right?
Yes.
Okay, but you didn't give them that opportunity, did you?
That's what this hearing is for.
Okay, but at the same day that you filed these charges to I let the cat out of the bag there, didn't I? Same day you filed these charges to this board, who else did you file charges with?
Well, I just want to, the board hasn't received any information from administration, to my understanding, and this is the first time they're receiving information tonight.
Okay, great. Can you
Right,
answer my
correct.
question
Yeah, true.
of whether or not you filed charges with Wisconsin Department of Public Instruction to have this teacher here lose her teaching license?
I'm required.
Oh, okay. So you didn't wait. In other words, you didn't wait
Reports.
for the board to make a decision. You had already made your decision. True?
I'm required to make those reports.
And you'll agree with me that even if this board here decides against you, that you're still threatening Mrs. McCarthy's teaching license, right?
I am not. I do not have that authority. The DPI conducts their own investigation.
Okay. And you didn't wait for the police to be done, right?
Two separate investigations, sir.
Well, you didn't even finish your investigation at that point, did you?
You're going to have to give me more details and more of a question.
Well, you learned more information after you filed with DPI, didn't you?
I don't recall up until today receiving more information.
Well, for example, the police report, right?
That's today.
Well, and today's after when you filed with DPI, right?
Yes, sir.
Okay, it's the same again. This is the 12th, right? The same day you filed these charges.
I don't have that in front of me. I can't respond.
Okay. But you'll agree with me that at least the police, who were could continue to investigate, right? After you referred your charges to DPI, right?
I do not know that. I was not in contact with the police.
Okay, so you disagree that the police talked to a parent on September 22nd. Is that fair?
I don't have knowledge of that.
Okay. Well, let me just hand you page 10 of 30 of the police report that you read. Maybe that'll refresh your recollection there.
Again, I didn't read it, sir.
Well, you skimmed it to see if there were names in
There
there.
were student names.
Okay. Well, does that refresh your recollection at all?
Which portion did you want me to read?
Just, let's see, there's the three solid lines there. And where I read out, and be careful because it does have pupil identifying information in there.
So Attorney Hitchcock Cross, are you asking her to read that?
No, right now, yeah, but not out loud, please.
Yeah, I would prefer not to. It contains student initials.
Right, I think we covered that. But if not, I appreciate that clarification.